Hi, everybody. I'm Pat Dorsey with the GCAA. Thank you, Chris, for being here today to provide us this update on COVID-19. We're so appreciative of everything Chris does for the association. Just a few things as we get started. If you are wanting to ask a question, we will be fielding them in the Q&A box. Please put your questions in the Q&A box. And we will be recording this. It will be available by link after through the GCA website. And also, if you have any comments that you would like to share at the end regarding the experience or the webinar itself, please put them in your chat box. So on behalf of the GCA, we are happy you're here. We are very busy trying to do everything we can for our members and create as much valid information, up-to-date information on what the industry is going through at this difficult time. We want you to know that our e-blasts are going out on Tuesdays and Thursdays with up-to-date stories and information and webinars like this. And we are working hard to reschedule our calendar for everything that is coming our way for the, looks like, late spring, hopefully, but more assuredly the summer and the fall. We'll have the trade show, we'll have Top Golf, we'll have the golf tournament, all those things where we can hopefully come together and celebrate the end of this difficult time. So with that in mind, I will turn this over to Chris. Thank you.
Thank you, Pat. Good to see you.
You too.
I was going to do this. So I'm going to start off by doing a little moral support for everyone out there. I know we're all sick of being in quarantine, and we're being told by everybody that these next weeks are the ones that are going to hopefully give us our summer back. So I brought my moral support mask. So put your mask on. Don't be afraid to use it. I look like a train robber, but really I think everyone needs to know, and we all need to support each other. If you can keep from infecting a few other people, then maybe we all get our summer vacations back. So to the extent you can, have one of these masks handy if you need to go pick up takeout food, or if you need to go to a Harris Teeter or a Publix, make sure you got one of these to wear while you're in there. Okay? All right. Public service announcement 785,242. All right. So with that said, we're going to chat briefly today for those of you that are now into the late fee week of the month. We are rapidly trying to field all the questions we can from our clients about how do we collect rent in the face of the federal moratorium, and what do we do, and what are the best practices that we need to follow. So of course, first step and most important step is hopefully everybody figured out before Monday what their status was under the CARES Act, so that they knew whether they were or were not allowed to charge late fees this week. But we'll talk about that in a little bit more detail as we get further into our best practices memo here. NAA put this out just days after, it's on the screen, they put this out just days after the CARES Act was enacted by Congress and the President. Friday, March 27th, it was in place as of before the close of business that day. The best practices email that NAA put out that Sunday on the 29th is a really good, handy thing to keep at your desk so that you can answer questions or help your staff answer questions. It will be attached to the email you'll get from Pat after we finish, so that you'll have easy access to it. It's available on the NAA's COVID-19 webpage as well, so it's easy to find if you need to. Of course, they start off like any good white paper does by saying this document is not legal advice. It is not specific to any particular person. It's just a series of best practices, but you should always consult with your local counsel about specific questions that apply to your property. As a general rule, when I do webinars like this, I'll say the same thing. I'd be happy to field questions. Michael and I have gotten really good at taking questions as they come in if they're relating to a particular section that we're talking about. So feel free to type them in whenever you think of them. Michael will interrupt me to answer a question if he thinks it's a good spot in the conversation to do so. But I'll tell you that I'm not the attorney for everybody who might be participating. I know we have some guests from the city of Charlotte that are on our chain today. So, I'm not here as, even though I represent probably lots of the people that are on this call, I'm not here as your lawyer. I'm here as a practitioner who wants to try and help you get some good guidance. If you have specific questions about your particular property or a particular situation, do what you always are told to do by us anyway, and that is call your local attorney and ask them specifically to help you with some legal advice and counsel on your particular situation. So please don't be offended if I tell you that I can't answer that question because it's too specific. It's very obvious that it's fact specific to your property. And so the first paragraph of this NAA letter says the same thing. It's not intended to be an answer for every question. It's not intended to be universally applicable. It is a series of guides that are hopefully going to help people make some good decisions about what the best practices are in this time of completely unexpected and unanticipated change in the law and operational styles. The purpose of the white paper is to provide guidance to the National Apartment Association members regarding your rent collections activities during the middle of the COVID-19 crisis. An overview in response to the pandemic, the financial hardships residents are experiencing. Again, not universally experiencing, but all of us are experiencing a lot of disruption. And even in regards to people who are not unemployed right now and who are still working, like those of us on this call are, it's still impacting our lives in ways that are unusual, unanticipated, and hard to predict. And so I think this guidance and what you're doing about rent collection, it's important to keep in mind that it isn't just people that have lost their jobs that have suffered economic hardships. Any number of people may have had a spouse who lost a job. Any number of people may have had a spouse or a family member who ended up in the hospital, requiring them to be away from their work for many days at a time. They may not be paying attention to their rent due date this month because they may be in the middle of caring for a loved one. There's a million things that could, in a situation like this one, could impact people's ability to pay rent. And they aren't all because people are trying to take advantage of the system or are pretending like they're going to be on rent strike or pretending like they're just going to ignore you until you do something about it. Many of them are going to have legitimate reasons. And so being flexible and being willing to listen to those reasons is a key part of the guidance you're going to hear today. NAA has been working diligently putting out these white papers and others all over the place ever since this started, trying to assist owners and managers with guidance on their operations relating to resident collections. With employees experiencing mass layoffs due to the virus, millions of Americans face the prospect of not being able to pay rent, or at least not in the short term. Local, state, and federal authorities have introduced eviction moratoriums across the country in response to the coronavirus crisis, and many owners and managers are planning for worst-case scenarios. So it's important to recognize that the NAA, its affiliates like GCAA and PAT, individual members, they're not healthcare professionals. None of us know exactly what the right answers are. This is a medical emergency that's never existed before, and so everyone is doing their best literally on a daily basis to try and adapt, learn, understand, and evaluate what the actual medical science is behind this and what is really the best practice situation. That guidance changes actually every day. But in terms of what should you do as a best practice item, these are the best ones we have, and these are still valid today. So start one, collecting rent. Guides number one in our sheet here. While rent collection should continue in accordance with your lease agreement, obviously, you need the income. You can't just have rent disappear. There's nobody coming to save the day and pay the rent for the residents at this point anyway. We ask you to recognize that some residents, and in fact, many residents perhaps, have been or will be financially impacted by COVID-19. Consider working with those residents on alternate payment schedules. Consider waiving late fees. You may be required to waive late fees. And provide financial resources to residents where applicable, helping them have access to information about where they might look in the community to get help for making rent payments in a time of crisis. Having those kinds of resources available that you can hand out to residents, a great idea. There's no reason not to point residents towards crisis assistance ministries or the Salvation Army or others that may have that kind of help available. You want the residents to get help. You don't want to discourage them from getting that help in this time where you need all the help you can get to make sure the rent comes in as much as you can get it. To prevent continued exposure, residents should be encouraged to pay rent online at the options available at their community. You want to help folks get that connectivity. You want them to be able to avoid the leasing office at all possible. You know, many of you have gone to no contact leasing offices where, you know, residents can be helped by appointment only via phone or email, but people don't come to the office other than employees of the company. Well, that's going to make it hard to collect rent in person. And so that may be a situation that it's important to be mindful of the varying obligations that you have. You have to accept people's payments if they want to make them. And you can't force them to go immediately to online only payments because your lease doesn't allow you to do that just unilaterally. So you probably are going to need to make arrangements for alternative methodologies. You may have to bring back a lockbox. You may have to install a slot in your office door that, since the office door is locked at all times, you could have a mail payment slot that goes there instead. Any number of things might be necessary in order to make sure that people have the ability to make payments to you, because you can't just unilaterally change your way of collecting rent without everyone agreeing to it. You have a contract, and unless it's specifically said ahead of time that you only accept electronic payments, then residents have the ability and are empowered under their contracts to make payment however they can. You're going to want to make sure that you have the facilities to allow them to make payments whatever way they can do it. Employees should handle all money collection with disposable gloves and wash their hands accordingly, just as a measure of safety. If you do get checks, make sure you're doing that, and make sure your employees are religious about that to make sure that they stay safe in this time as well. Other things to keep in mind about collecting rent. If you are trying to get people to pay rent and they have any sort of medical emergency, permanent disability, or otherwise someone who is entitled to make a reasonable accommodation under the Fair Housing Act, you're going to have to be mindful that they might have an issue with whatever rent collection methods you're implementing. If you have closed the office in full and they're an elderly resident who doesn't have an online payment portal, just because you have one doesn't mean the resident knows how to use it. You might expect that some folks may come to you and ask for accommodations in how you're collecting rent from them. There are different ways to do it. You might have to even consider something like, if a resident, for example, were to say, can't you send one of the maintenance gentlemen to the office? I can leave my envelope with my rent check outside my door for him to pick up. That's an accommodation. It's not something you would do normally. Of course, you wouldn't want to do that without some safeguards in place. But if the resident said, I'm ill, I'm self-quarantining, and I don't know how to use the online payment portal, you might have to make some unique arrangements like that. Those are things that you've got to consider, because collecting rent is necessary. The resident who's experiencing a financial or a medical, maybe it's not an emergency, but maybe it's a situation that requires immediate attention on their part. If they're actually in quarantine, they can't leave their house, and if they don't know how to use the online payment portal, you're either going to not get their rent, or you're going to have to consider an accommodation if they were to tell you that's why they need your help getting the rent to you. So those are unique things that we don't ever deal with on a regular basis, but you might have to deal with them this month. You might have to deal with them next month. And keep in mind that the Fair Housing Act continues to apply. And if someone has a disability, like I'm suffering or maybe suffering from coronavirus and therefore have to self-quarantine, that's a reasonable accommodation request that you have to consider and analyze. And if you need help figuring out how to respond to it, good time to call your friendly neighborhood lawyer and ask them for help responding to that situation. Don't just use your knee-jerk reaction for those things, because they are not always the right answer. Knee-jerk reactions are often misinformed. Okay, so moving on
Chris,
to collecting. Yeah.
what if due to an appeal, the resident is currently paying their rent to the court? How can the property get that rent?
They can't. As of right now, I just answered this question for a client the other day. As of right now, the money's being held at the courthouse, and the courthouse isn't conducting any hearings in North Carolina, and they aren't going to be until June 1st. So all you can do for the moment is check with the courthouse and confirm that payment was made, so that you know that the resident is at least current on their payment. but you're not going to have the money until the court reopens for business, schedules your case for a hearing, and a judge can issue an order directing that those monies be dispersed, as the usual practice is. But in a time where the courts aren't conducting hearings, there isn't any other plan B here. The court's holding the money, and the court's going to keep holding the money, and you're just going to be forced to be patient. When the hearings are conducted again, the judges will, of course, be directing the bookkeeping department to issue checks to people that are entitled to the money. But in the meantime, there isn't a way to get them by calling and asking. Late fees. So another item on the collection of rent issue is late fee charging. So as I said at the beginning, hopefully you all already analyzed this issue, found out from your home office whether you could or could not charge late fees. As a courtesy, NAA has provided a notice of temporary waiver of late fees form. They developed this. So even if your property is exempt from the CARES Act and is not subject to the moratorium that we're going to talk about here in just a few minutes, you might still choose to waive late fees this month as a courtesy, as a PR, as a recognition of the crisis, as a good neighbor policy, even if you didn't have to because of the law. So NAA crafted a notice of temporary waiver. The form allows operators to waive late fees incurred by residents who, as a result of COVID-19 issues, are experiencing loss of wages, unemployment, or unexpected medical expenses. The form is available in Blue Moon now. It's also available on the COVID resources page of the NAA. And you want to make sure, but it has been approved here in North Carolina. But as with all NAA forms that are available through Blue Moon, please consult your local attorney before you implement those forms into your operations. Make sure you know what you're doing and how you're doing it. The methodology you choose to apply matters here because, again, the Fair Housing Act hasn't been suspended. And so if you choose to waive late fees only for certain people, but not waive late fees for certain other people, you're going to need to make sure that you're doing that in accordance with a very well-crafted policy that's been reviewed for Fair Housing Act issues. You want to make sure that you've consulted with your counsel about what your policy should say and what your policy shouldn't say, and make sure that you've gotten all that buttoned up before you start offering to waive late fees for certain people, but not others. Fair Housing Act is not going away. It's not going to be waived. It's going to continue to apply. So any treatment of any certain category of your residents that is different from the treatment you give to a certain other category of your residents is always subject to scrutiny. That's why in these situations, creating a waiver for people that have been impacted, but not waiving for people that weren't impacted is really important that you get that done correctly. Another item that comes up is payment plans. So in this time of crisis, many clients have told us that they are and are regularly encouraging their residents to come up with payment plans in lieu of insisting on payment in full. Many professionals have already have individual plans in place to work with their residents during this unprecedented crisis. There's no one-size-fits-all approach. The best strategy, NAA recommends this, is for owners, managers, and residents to partner together to find the optimal solution at your particular community. Again, NAA responded to demand from the constituency across the country and again got together and drafted up and provided a payment plan agreement, which is a COVID-19 pandemic form. The form allows residents who, again, as a result of COVID-19, are experiencing loss of wages, unemployment, or unexpected medical expenses, to agree with their landlord to pay rent and other monies owed at a later date, or to pay part now and part at a later date. Payment plans should be agreed to by both the owner and the resident affected. In every situation, a lease is a contract, and you cannot modify a contract without all the parties to that contract agreeing to the modification. So in a situation like this, where you are talking to your residents about coming up with an alternative to the usual plan, the requirements of the lease are being changed. That plan ought to be in writing and it ought to be signed by everybody. Why? Because if there's ever a question about what the agreement was, what did they agree to pay? How much did they agree to pay? When did they agree to pay it? There is no best alternative to having it all written down in a black and white document. If you allow things to happen verbally that don't get memorialized in writing, you always create ever increasing risks that it'll be hard to prove what the agreement was later. And in a situation like this, where we know that the pandemic is likely to last for a period of time, later is an important time frame to remember. A lot of what goes on today is going to be relevant for many months down the road. Payment agreements are going to be important for several months at a time. And you're going to need to be able to prove what those things were, what the documentation said, perhaps as late as August of this year. When the moratorium finally lifts and we are allowed to start evicting people again who just refuse to participate and don't honor their agreements, you're going to want to make sure that you know why. Again, the NAA COVID-19 resources page has all the additional information you might want about this form. Again, it's not been approved in every jurisdiction, but in grand scheme of things, there is a form that is easily available and adaptable to North Carolina operations. There is also an AANC form that has been put out for those that are interested. And so if you're on the AANC lease, the state board authorized Norm Prate to put that together, and that's been released as well. So again, make sure you're consulting with your attorney about which form to use, whether it matches up with the program you want to put in place. All of those sorts of things will be important. And then NAA also wants people to know that they have created and fast-tracked the release of a new compliance solutions called Click and Comply. The rent relief form that's in there, property management companies can utilize across your portfolio, will easily document and track requests from residents who are financially affected by COVID-19, including special arrangements or payment plans that have been agreed on by the property and its residents. The form is free for 6 months and allows property management companies to pull one report for each property, allowing you to overview the entire portfolio in a snapshot. So if you're interested in that form, there's a contact email in here for you guys to look up and consider. When you have a payment plan, and if you were trying to differentiate among who is eligible for our plan and who is not eligible, you want to consider a number of these items here. Things you may wish to consider. A, did the resident lose a job or have their working hours reduced? B, can the resident provide verification of employment status change? Does that verification even exist? C, does the reduction in income put the resident below the typical 1/3 rent to income ratio? For instance, if they lose their job or they lose their hours but don't lose all of their income, does that change their status? And does that make them less likely to be able to even meet the monthly requirements at all? What other external factors related to COVID-19 contribute to the loss of income? One of these external factors is the availability of unemployment compensation. We all know that the government at all levels, state and federal, has made it a priority to ensure that people who are losing their jobs because of the virus and its impact are going to be compensated with essentially 100% paycheck replacement, and in some cases more than that. The federal government's working on an additional enhancement to state availability of unemployment benefits. So while someone may have a crisis in April, they may have no crisis in May because the government has stepped in, they've received their unemployment check, and have been paid in full for the wages they lost, and they didn't suffer any loss of income at all. So you may want to consider external factors like when did they get unemployment, whether they're getting unemployment, if so, when's their first check arriving, is it actually payment in full? Other external factors, the stimulus plan bonus check. When do people get their $1,200 from the government? Has it been received? For most people, that's going to cover almost all of their rent payment. It's more than the average monthly rent in the state of North Carolina for a 2-bedroom apartment. So but again, nobody I know has gotten their stimulus check yet. And so until those checks arrive, that's a factor. It's an external factor that's important to consider in what kind of payment plan are you working out with people. Because if you know that they're going to get a stimulus check and you know that that's enough to cover their rent deficiency, then that would impact what kind of payment plan you might want to put them on. Also, does the resident have an on-time payment history? What kind of resident is this? Are you willing to work with people that are habitual late payers that you have to continually file eviction cases on to chase them down for payment? That may impact your analysis of what kind of agreements you want to reach with them. And then lastly, should you ask the resident to suggest a payment structure they believe they could meet? It's an important question. Oftentimes, if you suggest to the resident what you want them to do, you may not get a fully honest answer about whether they can or can't do that. They may tell you that they can, knowing that they have great doubt about whether that's available. And that isn't likely to be a very successful relationship then. If they're over-promising, but they can't deliver on the promise because you suggested it, then that doesn't really benefit you any more than it does them. And so the idea here, NA is suggesting, is that maybe you might consider doing it backwards. Ask the resident, we're willing to consider a payment plan. What payment plan could you make? How are we going to get your April rent paid? What kind of structure do you need in order to be able to get that taken care of for us? And then listen to what they say before you accept or reject. That's an approach that has a greater likelihood of you getting the money because the resident is proposing something that they've already thought of that they could get worked out. Very important distinction that's purely psychological. Next item, item 4, resident communications. So a key part of what we're doing right now, and the reason why debt collection is the title of the seminar really, is what you communicate to your residents during this time is not just a fair housing concern issue, but it's also a fair debt collection practices concern issue. Remember, what you say in writing and what you tell residents they must do is going to be used against you in a court of law later if it's wrong. So every letter you write, every collection attempt you make, every email you send right now needs to be accurate, needs to be compliant with the law, needs to not be asking for amounts that aren't due. So if you find out that you send a late letter on Monday the 6th, like you normally would in every month, but it turns out that on Wednesday your CFO let you know that our property is covered by the CARES Act, and so we're under the moratorium, and we're not allowed to charge late fees anymore until August, well, that's going to be a problem because your late letter that was sent on Monday is now a Fair Debt Collection Practices Act violation. You demanded that they pay you demanded that they pay a late fee that they don't actually owe. And just because you didn't know that until Wednesday doesn't mean that it's not still a violation, because the law went into effect on March 27th. If your letter went out on April 6th, the law assumes that you would have figured that out before you sent the letter. And the fact that you did or didn't figure it out is not a matter that the law cares about. So you have to be mindful of what you're saying in those communications. I've had client after client ask me, do we need to change our late letter? And the answer is, I don't know. Are you a covered property? If so, then you probably need to change your late letter because your late letter probably says that they owe you a late fee. And now, if you're a covered property, they don't. For the next 4 months, they don't owe you a late fee at all. So yeah, in that situation, you probably do need to change your late letter. Also, since you can't file any eviction cases if you're a covered property, you got to be mindful of what your communication says about that too. If you have standard language in your late letter that says, if we don't hear from you by a certain period of time, then we're going to refer the matter to our attorneys for the preparation and filing of an eviction action. Well, that would be wrong right now also, because the moratorium applies to eviction actions too. And so you can't threaten the resident by saying, we're going to turn you over to the attorneys for the preparation and filing of an eviction, because the law says your attorneys aren't allowed to file evictions until at least August 26th. And so that's a different kind of fair housing violation. You're threatening legal action when you're not allowed to take it. And so, yeah, I think it's very important for people who don't know for sure whether they're covered by the CARES Act, remember that you need to figure that out and you need to modify your communications so that they are compliant.
Correct.
Besides the legality, yes.
Sorry to interrupt. I just got a message that this was announced on the website that it was only a 30-minute meeting, but we are planning on an hour. So if anybody does need to jump off because you thought this was only 30 minutes, don't worry. We are recording it and we're going to share the link to the video later on. So just in case someone does need to pop off, we are recording. The link will be shared by GCAA, and then our firm will also post it on our YouTube page. And then I've got one question for you if you want to take a question.
Yeah, go ahead.
Okay. So Holly was wondering how, back up to what you were just covering about the payment plans, what do you suggest is a reasonable time for a payment plan? How many months, weeks?
You know,
What do you think?
yeah, you know, there's really, it's a good question. And I've gotten a lot of clients that are doing things that are, you know, truly across a spectrum of options. To me, if I was evaluating it, I would follow the guidance from HUD or from NAA here and focus on what is the actual situation that this particular resident is in. If they are in a situation where they need to be in quarantine for 2 weeks, and so they're going to have a temporary loss of income, then that's one kind of scenario where they might not need nor should expect a long window of repayment. Someone else who's been completely let go of their job because the business has been ordered to be closed, let's say a hairdresser, and there's no chance that they're getting their job back anytime soon, then that may be a different situation. But layered on top of that, then you've got the availability of unemployment benefits. And so it really depends on what that person's situation is, and there isn't going to be a one-size-fits-all answer. But certainly, you know, the moratorium only lasts for 120 days, and so I can't imagine a scenario where anybody would allow someone more than that period of time to get back up to speed. But whether you're deferring some of this month's payment into next month, or whether you're splitting it up into equal payments over the next 3 months, you know, I've heard all combinations of those things from clients, and you know, just depending on, I think depending on your property dynamics and what kind of delinquency you're experiencing, that would probably have some impact on what kinds of payment terms you're allowed to give out or you ought to be considering. I really do think that there's a lot that goes into the analysis, but I can't envision anybody giving their residents more than the 120 days of the moratorium in any event to get, you know, all payments current and in full. Back to the communications piece. In addition to just how you communicate about late fees and unpaid rent, you also want to remember to communicate extensively with your residents about what you're doing, which many of you are already good on, but also you want to communicate about what your options are. You want to let residents know that if they've suffered a COVID-related loss of income, that you understand that and that you have options for them to discuss. You don't want to wait for them to come to you because many people won't do that. And more importantly, it might even create a fair housing problem if you do that. But waiting for people to come to you is not a good idea. Communicating out to the residents that you are willing and open to talking about accepting partial payments now and making payment plans for the balances. Those are things that will encourage people to feel comfortable paying you what they can pay you. In a time like this, anybody who has had a partial payments or not accepted mantra should stop immediately. In North Carolina and South Carolina, you're allowed to accept partial payments. If you're using the AANC lease or the NAA lease, you can accept partial payments with impunity at any time. And in this kind of era, in this kind of crisis moment, you want every penny in the door you can get. So telling your residents that that's part of what's going on right now is important. And if you don't let them know those things, they will probably, or at least some of them, will just assume that they were told in the past that you guys don't accept partial payments, so they don't pay you at all. Because I know I only have $600 and they told me they don't take partial payments last year when I worked out that eviction case with them. So I'm just going to, you know, hope that I can get it, and I know they can't evict me yet, so maybe I'll be able to get it together. Well, you'd rather have the $600 right now. And so if you aren't communicating with your residents so that you're setting their expectations, that they know that you're willing to work with them, they know that you are not doing business as usual, and that you are accepting partial payments in whatever amount they can bring. Those are things that will encourage people to come in and make the payments. And that's the kind of encouragement you want them to be aware of, so that you get more money in the door. Whatever you can get is better than allowing residents to do it themselves. Don't wait for them to come to you. Make sure your communication is bringing the knowledge to them. You may want to consider asking affected residents to provide documentation from their employer or other documentation about the impact. But before you do, make sure you check. You know, in North Carolina, for example, we don't have any executive orders or other governmental regulations that prohibit you from seeking confirmation of people's affected status. But obviously, your portfolio may extend beyond our borders, so be cognizant of that. frequently and timely communication is the best course of action in a time like this. You know, you don't want to say the same thing 17 times in a week, but you do want to perhaps consider sending 17 messages a week to your residents so that they're getting the information fresh and new as it becomes available. Keep updating them with any new property procedures or policy notices. Keep reminding them of your flexibility and your willingness to work with them so that you can get rent payment in the door. All of those things are helpful. The next item on our list here is evictions. And this one obviously gets us to the law itself. The moratorium on evictions is contained within the CARES Act. Before you decide to initiate eviction actions right now, you really do need to consult with your legal counsel. You know, our firm handles eviction cases for a large swath of the multifamily industry here in Charlotte. And we have lots of clients that are across the spectrum of I am covered, I'm not covered, or I'm not sure. And how do I find out? And those kinds of issues really make it a challenge to know that come next week when, you know, a lot of people would normally start their eviction filing protocols, we have a bunch of people that are going to need to know for sure whether they're even allowed to or not. And in order to make those decisions, you need to be in touch with your attorneys, whether it's our firm or whether it's Brownlee, Whitlow and Prade or somebody else. Those are the things you need to be sure that you understand. Also falling into this category are notices to vacate. Even if you've got a rent-related issue and you can't file eviction, can you demand they leave anyway in hopes that they'll move out voluntarily? The answer is no, not if you're a covered property. And so those sorts of questions are all mixed together with the actual statute that was put in place. And we're going to talk about that in just a minute. In our conversations earlier in our little fireside chats like this, back in the last weeks of March, on March 25th, the Federal Housing Finance Agency issued a public service announcement, really letting people know that they were going to be giving out a forbearance relief package of their own making. This is before the CARES Act was passed. And that gave us the first inkling that eviction-related moratoriums were going to be part of the puzzle here, a piece of the puzzle. In that announcement, they said that Fannie Mae and Freddie Mac are going to give forbearance for up to 90 days for their loan recipients. So if you've got a mortgage from Fannie or Freddie, your property was going to be allowed to take a forbearance relief package, but in exchange, they were going to have to agree to forbear on evicting people on those properties for the same 90 days that they got forbearance. Well, on March 27th, Congress got involved, and we took it from a cabinet position, housing finance agency decision to a law. And so on March 27th, President Trump signed the Coronavirus Aid, Relief, and Economic Security Act, which now everyone knows as the CARES Act, into law. Similar to the announcement by the FHFA, the CARES Act introduces and includes a provision that allows owners of properties to have a federally backed multifamily mortgage loan to seek forbearance because of a financial hardship during the COVID-19 emergency for up to 90 days. That's in section 4023 of the Act. We're going to go through it here in just a minute. Additionally, a multifamily borrower that receives forbearance under this section may not issue a notice to vacate until after the expiration of the forbearance period. And you cannot require a renter to vacate until 30 days after the notice to vacate has been issued. So separate and apart from that section, that was section 4023, but really the one that matters for everybody's purposes is section 4024 of the CARES Act. And Michael's got that, and we can load that up here and we'll go through it real quick. Okay, so here's the actual text of the law. And if you zoom in there and check it out, the section 4024 is called the Temporary Moratorium on Eviction Filings. So it truly and genuinely indicates that Congress has made clear that they want landlords across the country who are covered by this act to stop filing eviction cases. And they go through, as is usual in a statute, they go through a definition section first. And that starts with what is a covered dwelling. And of course, a covered dwelling A dwelling covered by the act is one that's occupied by a tenant pursuant to a residential lease or a verbal lease without a lease that's terminable under state law. So essentially, every rental property in your state or in the country is a covered dwelling, as long as it is B, on a covered property. So, you know, if you have an apartment and it's located within an apartment community, what you need to know is that apartment is a covered dwelling if it is part of a covered property. And then the next definition, of course, covered property means a property that participates in a federal housing program. That's A. So if you know, we can go through that list here in a minute, but if you're part of a federal program, then obviously you're covered. But B, more importantly, if you're a regular property and you're not covered by a governmental program at all, you are still covered and you are still subject to the moratorium if your property has a federally backed multifamily mortgage loan, or if it's a single family property, it just has a federally backed mortgage loan. But the definition of federally backed multifamily mortgage loan that's where the proof is in the pudding. Knowing what that means is what comes next. So section 4 of the definition section is, well, that's federally backed mortgage loan, but section 5 is federally backed multifamily mortgage loan. It means that it is any financing that is secured by a first or second lien on a residential multifamily real property designed for occupancy by 5 or more families, and it's made, the loan that secures a multifamily property is made in whole or in part, or it's insured, or it's guaranteed, or it's supplemented, or it's assisted in any way by any agency of the federal government, or under or in connection with a housing program administered by the Secretary of Housing and Urban Development, HUD. So what does that mean? That definition is designed to be super broad. It's made in whole or in part, or the loan is insured by, guaranteed by, supplemented by, or assisted by Fannie Mae, Freddie Mac, or some other agency of the government. That is a very broad net, and it's very intentional. They wanted this moratorium to apply to as many landlords as they could make a definition. The government can't just tell all landlords that you can't have a moratorium. That would be a constitutional violation. A private landowner's rights to do with his land as they want and their right to redress at the courts cannot be deprived by the government. But the government can say, because there is federal money involved and because there is federal aid involved, they are allowed to make restrictions to the recipients of the federal money. That's the bargain here. And so because of that, if you have a federally supported loan on your property, you are covered by the moratorium. In terms of examples of what kind of programs are we talking about, the programs that would qualify you for being a covered dwelling or a covered property also are things like the supportive housing for the elderly program, the housing for persons with disabilities program, the housing opportunities for persons with AIDS programs, the McKinney-Vento homelessness assistance program, the below market reduced interest rate programs, Section 8 housing choice voucher program, Section 8 project-based housing, home guarantees, rural housing assistance programs, and low-income housing tax credits. So if you are any of those things, you may have a covered dwelling, you may have a covered property. The fact of the matter is that if you are one of those properties, then you have to go back and figure out, what does the moratorium actually say? So now we go down to B. The moratorium itself, if you are a covered property, then you are subject to this moratorium. During the 120 days, beginning on the date of the enactment of this act, March 27th, 120 days after that is July 25th. So through July 25th, the landlord of a covered dwelling may not, first, they may not cause or ask for the filing of a legal action to recover possession of a covered dwelling in any court that has jurisdiction from their tenants based on, for non-payment of rent or other fees or charges. Super key point. We'll get back to that in just a second. Or 2, they may not charge fees, penalties, or other charges to the tenant related to non-payment of rent. So Late fees are clearly included. Late fees are moratoriumed through July 25th. It also includes Nsf fees, I think. I've had this question asked a number of times. If a resident pays you their rent with a check that comes back bad, that is a charge. The Nsf fee would be a charge that you are levying to the tenant related to their non-payment of rent. Their check bounced, you didn't get the rent payment. If it was a rent check, that would not apply to an Nsf fee if they were trying to pay you a water bill with a separate check. Paying the water bill would still be separate from this moratorium, and you would be allowed to charge an Nsf fee for that payment. What the immediate question I always get is, what if they do both? Like, it doesn't say. I'm reading the same language you are. If it was a payment related to the non-payment of rent, meaning rent was in the payment, I think you're not allowed to charge an Nsf fee, even if they included other things in the payment too. If they were paying off their whole ledger balance, including water bills and other fees and charges that aren't rent, and that check bounced, I think the Nsf fee is not allowed to be charged there either. Again, no Nsf fees for rent payments through July 25th. No late fees for any month through July 25th. So you can start charging late fees again on August 1st. But the big one, going back to item 1, is the eviction moratorium. So if your property is covered and has a federally backed mortgage loan, then you may not hire an attorney or do it yourself, any eviction case filing in a court with jurisdiction over your property to initiate an eviction action. Now, in North Carolina, remember, our courts are not closed in North Carolina. Our courts are open for business. They are postponing hearings on all the cases due to the health crisis. They're not conducting public gatherings like a courthouse hearing would be because of the state of affairs of the health of the county or the county you're in. But the courts are open and they are accepting new cases. And so anytime you have an issue, you have to decide or figure out whether your property is subject to the moratorium, because if you're not subject to the moratorium, then you are allowed to file your eviction cases as normal against any resident who doesn't pay you on time by the deadline you've imposed. But even if you are subject to the moratorium, because your property has a multifamily, federally backed multifamily mortgage loan, you are only prohibited from filing eviction actions against a covered dwelling or against the tenant of a covered dwelling for the non-payment of rent or for non-payment of other fees or charges. Well, in North Carolina, you're not allowed to file an eviction action for other fees or charges. You can only file non-payment of rent evictions because of non-payment of rent. So remember, your lease has lots of provisions other than rent. And if you have a bunch of residents who are not following those other provisions of your lease, they have unauthorized occupants, they have unauthorized pets, they allowed the utilities to revert to your name instead of theirs, they allowed their renter's insurance to lapse, they're engaging in smoking in a non-smoking community, they're smoking in a regular community in areas that aren't approved for smoking, they are smoking marijuana where that's not allowed at all, they are disturbing your maintenance staff because they're freaked out about the COVID requirements and they're interfering with your maintenance staff's ability to do their job by being a lunatic when they see a maintenance person out on the community. Any of those things are all lease violations. They're engaging in loud parties late at night, even though people are supposed to be indoors. All of those things are lease violations. All of those things are things that in this time, during the period of this moratorium, you can act on those because they're not covered by the definition of the moratorium. Taking time to weed out the bad apples from your barrel while you are prohibited from just evicting people because of their non-payment is a strategy that we recommend. There's no reason not to consider those to be the people that you make sure that you are addressing now that you have a forced window of time where you're not able to deal with non-payment cases like you usually would. Now is the time to focus on the people that are causing actual problems for the residents in your community and consider removing them, because you're still allowed to do that during the moratorium period. Those cases based on that type are not barred. They're not prohibited. They're not suspended. So those are the big ones. Remember those things. You should also communicate to your residents, and Congress actually put out an FAQ document after the statute went into effect that makes this clear as well. covered properties, even if you are covered by the CARES Act, there's nothing in the act that is an absolution for the resident. They are still obligated to their lease contracts. They are still required to pay rent. They are still expected to pay rent. The 120-day suspension in no way removes the resident's responsibility to pay their rent or to comply with the terms of their lease agreement. It simply isn't an opportunity for the residents to use a get out of jail free card. That's not what this is. This is a gratuity extended by the government in recognition of the unexpected and overwhelming challenges created by this crisis, and protecting residents who otherwise may have a hard time exerting their own rights in a time of serious crisis is why this act was put in place. But it's not in place as some method of approving or otherwise giving people an out from their legitimate lease obligations. The owners of the properties you work for all have an obligation to banks to pay loans and to make money for the owners to pay their own bills. You have to earn money off of these communities to pay for the staff that work there. The residents do not have a free pass. They may have some time to get organized so that they can make arrangements to get their affairs in order, but that's it. You should make sure that you're communicating that to them politely, not in a hostile way, in a nice, professional way. And also bear in mind that states and localities continue to have their own items that are creating similar eviction-related issues. In South Carolina, for instance, the Supreme Court closed the courthouses until May 1st. We hope that that is actually going to be a deadline that sticks, and that after May 1st, the courthouses will be reopened, at least for the conduct of new case filings. We're not certain, but we're encouraged by some recent communications from the Chief Justice. But otherwise, you can't file any cases anywhere for any reason. There is a small carve out that the Chief Justice allowed for his South Carolina properties. If there was an imminent danger to life, limb, or property, and you could demonstrate that, the courts technically have the permission of the Chief Justice to accept those cases, but they're not required to. And the courts are making pretty clear that unless you have a police report showing an arrest for the criminal activity, they're going to be very skeptical about letting you file even those kinds of cases for the time being. In North Carolina, again, the courthouses are open for business, but the Chief Justice of the Supreme Court has ordered that hearings be suspended or continued into the future and not scheduled until after June 1st. So while there's no reason not to continue to file the cases so that you have preserved your place in line in case your residents don't go forward and do what they're supposed to do, you are aware of it. And then lastly, you want to have a resident resources opportunity. Make sure that you are telling your residents what the resources are. We covered this briefly in the resident communication section, but it cannot possibly do you any harm to tell the residents what community resources are available that might be able to help them gather together some more funds that they could use to pay you with, so that you can put more money in their ledger balance and reduce the amount that they are trying to work out a payment agreement with you on. So having a good set of resources, community guidance, the folks at the GCAA, Kim and her team, have those available. They're easy to find. You can certainly get those. They may even be able to include them in an email blast after this seminar. And then finally, payment incentives and renewals are the last part of the NAA white paper. Keep in mind that for leases that are ending during this moratorium, you're going to have complicating factors dealing with what you do with folks during that period of time. If your normal experience is that you give renewals to people or offer renewals to people with a rent increase, well, this might be the wrong time to tell people that they have to pay more money to keep living in your community. It also might be the wrong time to insist on compliance with a month-to-month fee arrangement. While that may be part of your regular practice, charging people $200 extra a month for not signing a long-term lease in the face of a crisis that makes it hard for anyone to predict what's going to happen next week, let alone 3 months from now, seems a little like it would be out of touch with reality and might put you in harm's way for negative reviews on social media and other places. So you might want to reevaluate what kind of renewal communications you're offering to people, and especially with regard to things like month-to-month fees. If you're getting rent at all, you probably are ahead of the game, and so telling people that you're going to insist on a strict month-to-month policy with month-to-month fees might not be your best approach. And then lastly, payment incentives. Residents have the financial capability to pay their rent on time, may be encouraged to do so if there's an incentive available. You know, for folks that haven't lost their job and who aren't suffering an economic hardship, you might be smart thinker if you were to figure out a way to incentivize those residents to pay on time by giving them a gift card or by extending some other benefit that you can that you're allowed to extend, rather than focusing on late fees. Maybe you think about, in this short window of time, you develop a policy that rewards early payment or on-time payment. Things like that can really help your budgeting, your bottom line, and really can be a nice way to boost morale in a time where everyone else is feeling very stressed out. And that's that. Realistically speaking, the crisis is going to be a long time winding down, and there's going to be a need for a lot of continued observation, a lot of continued attention to detail, and a lot of attention paid to what kind of information is being disseminated in the weeks and then months to come. But in the short term, if you're doing a good job right now, you're going to set yourself up for success as we go into May, June, July during the moratorium period. So again, thank you for your time. This is a great time. Michael can run through some questions if we've got them locked up, and then we'll be done.
Thank you, Chris. I appreciate your time as well. We actually don't have any pending questions. We covered them all.
Fantastic.
I did paste shortcuts to all of the documents that Chris shared into the chat, and we will send those out in follow-up emails as well. So if you miss those links or the documents, we'll make sure you have all of those with a link to the video that we recorded as well. Okay. So thank you, everybody, for your time. We appreciate it. Hope you have a great day and stay safe and healthy out there.